In this video, I'll be discussing when a legal recovery, like a lawsuit or settlement, is considered taxable to the client, the plaintiff. In other words, when will a plaintiff have to pay taxes on the money received from a legal settlement? Hi, my name is Greg Maxwell with Amicus Settlement Planners. I'm an attorney and a certified financial planner who helps plaintiff attorneys and plaintiffs reduce their taxes and maximize their legal recoveries. So when is a recovery going to be taxed to the plaintiff? Well, it's easier to start off by discussing when a recovery is not taxable. The only time a recovery is not taxable to a client is if the settlement is for a personal physical injury and when there are no punitive damages or post-judgment interest in the case. The most common types of cases where clients must pay taxes include employment and labor law cases, such as wrongful termination and harassment claims, defamation, libel, and privacy violations, emotional distress without a physical injury, fraud, negligence, and breach of contract cases, interference with property or contract cases, professional malpractice, and the list goes on. In addition, if there are punitive damages or post-judgment interest in a case, that portion of the settlement is taxable, even if it is a personal physical injury case. So essentially, the bottom line is if the case is not based on a personal physical injury, and there are no punitive damages or post-judgment interest in the physical injury case, the plaintiff will have to pay taxes on the recovery. So the bad news is that plaintiffs have to pay taxes on most legal recoveries. What's even worse is that in most cases, plaintiffs not only have to pay taxes on the portion they receive, but they also have to pay taxes on the attorney's fee portion of the case. So for example, if there's a settlement for $10 and the attorney's fee is $4, then the plaintiff will receive $6. Due to a change in the law in 2018, the plaintiff now has to pay taxes on the full $10, even though they only received $6. This is a huge problem, and one that we feel was just an oversight in the law, but it's how the law is currently written and currently stands. So the good news is that there are tax planning strategies that we can use to significantly reduce the amount of tax the plaintiff has to pay, and that allows to make it so that the plaintiff only pays the tax on the amount that they actually receive, or the $6 in the example. The plaintiff has been through something terrible, which is why there's a lawsuit in the first place. So the last thing we want is to make this situation even worse by having the plaintiff pay an enormous tax bill. We're often able to double or even triple the money the plaintiff ends up with after taxes by using these tax planning strategies. So if you're a plaintiff attorney or if you're the plaintiff himself or herself and an upcoming legal settlement will be taxed, please reach out to me. We can explore how these tax planning strategies may be able to work in your case.